Hi, everyone. Thank you guys for joining our first webinar titled How COVID-19 and the new DOL, or Department of Labor regulations, impact your business. We're just waiting for a few more people to join the call, but wanted to welcome all of you. My name is Jamy Smith. I am the Chief People Officer at Shakow Insurance. I have the pleasure of overseeing all of our human resource functions here at DSI, and I get to immerse myself in fun regulations like this that the Department of Labor throw at us quickly. I'm going to do my absolute best today to make sure that my dogs here at home do not disturb us. So if they happen to hear the mailman, the FedEx guy, or just the wind blow outside, I'll do my best to keep them from barking. It's one of the new challenges that all of us are facing from working from home. A couple reminders, as we're going through this webinar, if you have questions, I implore you to please type them in via the chat. We're going to give ample amount of time for questions towards the end, and I want to make sure that all of you get your answers to what you need to know about these new regulations. Also, I want to state that I am not an employment law attorney. So the advice that the information I'm giving you throughout this webinar is purely from my HR experience and all of the information that I've been doing based around this new FFCRA regulation. With that said, let's start. I want to first thank our DSI agents. This webinar came about because our associate agents, our commercial agents, and our group health agents got together and wanted to come up with some ways to help you as business owners navigate all of the crazy things that are going on in the past 4 weeks or so that are having such significant impacts on your business. So thank you to all of our DSI agents for coming up with this idea for the webinar. I also want to thank Catherine Lurch and also Madeline Boyd. Catherine is our Director of Training and Operations, and Madeline Boyd is our marketing guru. They're both working on the back end on this call to help everything run as smoothly as possible, and I appreciate their help. So this webinar, it's based around the Families First Coronavirus Response Act, or for short, the FFCRA. What is it? And there's a lot to it, but this is an act that requires certain employers to provide employees with paid sick leave and expanded family medical leave for specified reasons related specifically to COVID-19. So the one thing that you want to be clear is this is an expansion of the Family Medical Leave Act, or FMLA. This is not in addition to. So what that means is that up to 12 weeks of paid and unpaid leave that individuals can get under this new FFCRA is not in addition to the 12 weeks that individuals or employees can get under FMLA. It's just in combination with. So the FFCRA went into effect on April 1st, and it's going to last until at least December 31st of this year, and there is possibility for the government to extend it. Our friendly Department of Labor is giving until April 18th before they actually start enforcing violations to employers by not following the guidelines within this new act. So we have some time to get a really thorough understanding of what is encompassed in this act and what all of you as business owners need to do to make sure that you are in compliance with this new act. How is the new act different from the Family Medical Leave Act? So there are some very specific differences between both of these regulations. The Family Medical Leave Act is basically unpaid leave up to 12 weeks. Typically employees, if they go on FMLA, they will exhaust their accrued PTO time that they get from you all as business owners. And once they've exhausted that time, the remaining time up to 12 weeks is unpaid time. Also, to qualify for FMLA, the employee needs to be employed with you for at least 1 year. Also, the employee that's out on FMLA, their job is protected during that 12-week time frame, meaning that they have to be able to come back to their existing job or another job with the same level of seniority and responsibilities and also compensation. And employers who have greater than 50 employees for at least a 12-month time frame have to extend FMLA to their employees. Now the FFCRA, this is predominantly paid leave. We will talk about the two different aspects of the paid sick leave and the expanded family medical leave in a little bit, because that's the meat of this act. Now, one of the biggest differences from FMLA is that an employee now only has to be employed with your organization for 30 days to qualify for the sick leave or the expanded medical leave from your organization. All employers who have less than 500 employees within the US must extend this new FFCRA paid sick leave and expanded family medical leave to your employees. There is a slight difference in the job protection with the FFCRA versus FMLA. Employers with 25 or less employees do not fall under the job protection part of FFCRA. Now, I will caution you, technically, if you have less than 25 employees, you don't have to protect the person's job while they're out under one of the leave options in FFCRA. But it may be very difficult to prove that the person's role is a role that nobody else within your organization can do, or that if this person is out on FFCRA paid time, that it's detrimental from a financial aspect to your business. So you have the option, but I just caution you that if you were to get audited, you would have to explain it very thoroughly as to why you did not extend it. So who's eligible for paid leave and what companies must extend this leave? We talked about that a little bit during the FMLA difference, but right now, full-time and part-time employees are eligible for these paid leave options as long as they've been with you for at least 30 days. And also, if you have 500 or less employees, then you have to extend this new FFCRA paid leave time. What are the eligible reasons for paid leave? So this slide is going to show the required COVID-19 poster that now the Department of Labor is requiring all employers with 500 employees or less to post within your different offices. There's also a requirement that if your workers are remote, many of our workers are remote now because of what's going on, but if you also have permanent remote workers, you're also required to email this out to those employees so that they can have it on hand as well as posting it in your different office or locations that can be easily accessible to your employees to read. Now, the two separate paid leave options that you have under this new act is you have the paid sick leave. And if you can see my cursor here, under the paid sick leave options, 100% paid leave is qualified for reasons 1, 2, and 3. So the first reason is if an employee is subject to a federal, state, or local quarantine or isolation order related to COVID-19. Also, number 2 is if they've been advised by a healthcare provider to self-quarantine related to COVID-19, or if they're experiencing COVID-19 symptoms and they're seeking a medical diagnosis. So for those first 3 options, they're going to be paid 100% of their pay for the first 80 hours of this sick leave. Now, keep in mind, this sick leave, this paid sick leave under the FFCRA is in addition to. So you cannot require your employee to take the sick time or vacation time or any accrued time that you offer to them as them being your employee. This is in addition to. Now, one of the things I want to touch base here is number 2 and 3. So if they've been advised by a healthcare provider to self-quarantine or if they have symptoms, the Department of Labor has now given regulation and updates that these employees need to provide you with a medical note or some sort of diagnosis from the doctor that they need to provide to you to let you know that they need to go in self-quarantine. Options 1 through 3, again, all of that time must be taken together. So if someone falls under one of those first 3 categories and they're receiving 100% of their paid sick leave, they need to take it all together. It cannot be taken intermittent. And if for some reason after the first 80 hours they're not able to come back to work, then they have up to an additional 10 weeks of paid leave on top of the 80 hours that they took. And that's at 100% of their current pay. There is some stipulations that, if you look where my cursor is, up to $500 daily and $5,110 total for options 1 through 3. Now the other, actually, I'm sorry. So options 4 through 6 also fall under the paid leave as well. You have number 4, they're caring for an individual subject to an order described in self-quarantine as described in number 2, or if they're experiencing any other substantially similar conditions specified by the U.S. Department of Health and Human Services. Now, number 4, that can be taken intermittently. So if for some reason one of your employees is they need to take care of another individual that they're responsible for. So it's not as if it's just a random person that they decide that they want to take care of. They have to be responsible for. And if that happens, that can be taken intermittently. And you would just, as their employer, work that out with them. If they have an option to be able to telework or work from home, then they could do that. And during the time that they have to take care of the person they're taking care of, they would be paid for their regular work. If they're utilizing the paid sick time, then they would be paid their paid sick time, and you would just have to document that. If people are taking the options of the first 1 through 3 options, that time all needs to be taken together. That cannot be taken intermittently. So only the options 4 and 6 can be taken intermittently. Option number 6, that makes no sense. And the Department of Labor has not given any other guidelines around it. My only estimation with option number 6 is if that for some reason, if COVID-19 it morphs into something else, COVID-20, or it turns into some other different type of pandemic, that's giving the government the option of having one of the 6 options cover that already. But as of right now, that hasn't really been formally described from the Department of Labor as to specifically what they mean by that. Now, the other option to the FFCRA is the expanded family and medical leave. This is the one that can get a little hairy in terms of really understanding it. So if an employee comes to you and they tell you that they need to care for their child whose school or place of care has closed due to COVID-19 related reasons, that individual can be covered under the expanded family medical leave. And they've got a couple different options then. 1, the first 80 hours can be taken as either unpaid time. It can be taken as either they can use their accrued PTO time that you already offer them, or they can dip into their own paid sick leave that they're offered under the paid sick leave section. If they do that, if they were to be diagnosed with COVID-19 later on, they would not have 80 hours of paid sick leave of their own to utilize anymore because they would have taken it specifically for this to take care of their child. Now, the other option is they can do a combination of using their own accrued PTO time that you give them, along with dipping into some of their own paid sick leave under the paid sick leave option. That can get a little crazy to kind of manage. And all of this, if you have an employee who's utilizing either of these paid leave options, You're going to want to make sure that you document this as much as possible. One, for your benefit, for the employee's benefit, but also for your benefit as you get farther down the line when you go to file quarterly taxes and you want to use some of the tax credit for these paid leave options. Once the employee has exhausted their first 80 hours under the family medical leave, then if they can't come back to work, then they have the option of, again, the additional 10 weeks of paid time. Now, the expanded family and medical leave section, that 10 weeks of paid time is paid at 2/3 the employee's salary. It's not paid at 100% of their salary like the paid sick leave time is. Now, the employee could have the option to kind of supplement some of that expanded family medical leave once they're in weeks 3 to 12 of that 10 weeks time frame. If they wanted to supplement their time, they could use some of their PTO time to make themselves whole. So again, you're paying them 2/3 of their salary. If they had enough PTO time, they could use some of that to supplement to make themselves whole during that 10 weeks time frame. Now, the one way to potentially help you and also the employee is teleworking. If you have employees who need to quarantine themselves because of a medical diagnosis, or you have an employee who their children's school or daycare has closed and they need to take care of their child, then I would offer teleworking as much as possible, because then they have the option to still get work done, still earn money, and you're also making sure that you're also being assured that your work and your clients and your customers are getting taken care of. If for some reason they're teleworking but yet they're not able to focus on work, they're too sick, or the people that they're taking care of, they're too sick and it's causing them too much time away from work, well then that is when they're going to dip in to one of these paid leave options based on one of the 6 qualifying reasons that they may have. Some of the additional COVID resources that we at DSI have put together to help small business owners like yourself is we now have a COVID-19 Resources Center on our DSI website. If you go to our main page, up in the top right corner, you're going to see a COVID-19 resources button in blue. If you click on it, it's going to give you the business resources that we've listed along with individual resources. One of the sites that I would recommend that you go to is the Department of Labor. They have the COVID-19 fact sheets, Q&A, and also the required posters that you can download from there. You also have some of the options on the U.S. Small Business Administration or SBA site where you can take a look at some of the SBA loans, especially the new Paycheck Protection Loan Program that just launched last Friday. So the biggest part of this webinar was to get to your questions, and I see that there have been some that have chatted in. I have one that's asking, the additional 10 weeks are unpaid though, correct, for numbers 1 through 3. So if you go back to the employee required poster, so options 1 through 3, if they're subject to a federal, state, or local quarantine, if they've been advised by a healthcare provider to seek self-quarantine related due to COVID-19, or if they're experiencing COVID-19 symptoms and seeking medical diagnosis, those are the options that fall under the sick paid leave. So that 10-week period after they've exhausted the first 80 hours, that is all paid at 100% of their current compensation. Now, if you have an hourly employee or if you have part-time employees, those individuals are also eligible. And so you would have to do, according to the Department of Labor, a 6-month look back of their payroll and the hours that they've worked to determine what is that hourly employee's average compensation. And that is what you have to go off of as you move towards that 10 weeks of paid leave under the sick paid leave section. The only, to clarify that, the only time that it is not paid is, again, if it falls under number 5, where they're caring for their child whose school or place of care is closed. That's when they have to determine for the first 80 hours if they're going to use unpaid time, if they're going to use their PTO that they've accrued from you, or if they're going to dip into their paid sick leave option under FFCRA, or a combination of a couple of those. So that's the only time that this leave option is unpaid. Once they've exhausted the first 80 hours, that 10 weeks of time under the expanded family medical leave is still paid at 2/3 their compensation. It's the paid sick leave that's paid at 100% of their compensation. Another question is, how do we determine pay if our employee is paid by piece rate, not salary or hourly? Their pay varies week to week. That's a good question. My only recommendation is that you go back again and do that 6-month look back like you would with hourly employees and determine what the average compensation has been. And if for some reason, I see some other questions coming in about furloughing employees and, how does this pertain to individuals if you make a decision that after April 1st or April 18th, when this fully starts to get enforced, if you were to unfortunately close your doors, what happens then? So I would recommend, one, that you go back and take that look back period for the piece rate individuals. And if for some reason, if you needed to furlough or temporarily lay off employees based on financial decisions that pertain to the FFCRA, those individuals, including contractors, are now eligible to receive unemployment benefits. And you probably have learned that the unemployment benefits are being supplemented by the federal government with an additional $600 per week. And so they're extending that to contractors as well. Another question is, can you offer supplement if they choose option 5, get paid 2/3 and then work some time remotely to get a third paid as work? So yes, so if you have an employee who falls under option 5 and say that they're in their 10 weeks of time past the 80 hours, and so you're paying them at 2/3 their compensation, that time can be taken intermittently. That's one of the only options that can be taken intermittently. So if they are able to perform work, that's fantastic. If they're taking care of their child, and the child, they can entertain themselves for the most part during the day, then yes, that employee can still work. They don't have to be fully out on this paid expanded leave time frame. And I would encourage you, right now we're in a scenario where it's difficult for you guys as business owners, it's difficult for employees. The more that you guys can be flexible with your employees, the better right now. We have a couple employees here at DSI that we have changed their schedules around to be able to accommodate them to handle what they need to with their children during the day, while also being able to get done as much work as they can. So we have some employees who are starting later in the day so that their spouse or significant other can handle things in the afternoon. I would just encourage you and implore you to be as accommodating and flexible with your employees as possible now. That'll go a long way, especially when this is over. Another question is, you may have already said this and I may have missed out, but do they have to have a doctor's note or something subjecting them to a question to qualifying reasons 1 through 3? So yes, so a couple of reasons for that. So now the Department of Labor is requiring, if an employee comes to you with falling under one of these 3 or 4 or 5 options, they need to showcase some proof. It can be a doctor's note. It can be a simple statement with their name, what the reason is, and a diagnosis. If for some reason, if you have an employee whose school shuts down, they just have to, again, provide their name in a statement to you, give a little statement of what's happening, and also provide the school information. And you're going to want to maintain that documentation because that'll also be part of what you may want to or may have to submit when it comes towards submitting your quarterly taxes for tax credits when you have individuals who are out on this FFCRA leave time. Some other questions? Just give me 1 second. Our company already offers 2 weeks of paid sick leave. Do we need to offer an additional 2 weeks of paid leave? So again, yes. So this paid sick leave, even if you offer accrued sick leave, you still have to follow these FFCRA guidelines. So again, this is in addition to the paid sick leave that you're offering as an employer. You cannot require your employee to use any of their accrued time for this. This is all in addition to. Another question is, my employees work variable hours. How do I calculate paid sick leave for my hourly employees? So again, you're going to want to take that 6-month look back period to determine how many hours they worked, what was their average compensation. That'll help give you an understanding of what you need to compensate them for while they're out. If the employee's employment is terminated, do I have to pay them for paid sick time that is unused? The answer is no. So the FFCRA does not require financial or other reimbursement to an employee upon the employee's termination or if they were to separate voluntarily from employment when it pertains to any unused paid sick time under the Act. What is the extra 10 sick weeks you referred to after the initial 80 hours of sick? So the paid sick leave, you have the initial 80 hours of paid sick time that the employee is able to take for qualifying reasons 1 through 3. So they first get that 80 hours of paid sick leave time that they're compensated at 100% of their compensation. Then if for some reason they're not able to come back to work or telework, then under the paid sick leave entitlement, you are responsible for compensating them for up to an additional 10 weeks of time at 100% of whatever their compensation currently is. That's for the paid sick leave. For the expanded family medical leave, the first 80 hours is either unpaid. They can use their sick time their PTO time that they've accrued from you, and that can be sick time, vacation time, any of that accrued time, or they can dip into their own FFCRA paid sick leave. But keep in mind, if they get diagnosed with COVID-19 later on, they're not going to have that 80 hours of paid sick leave for them anymore if they dip into it. Or they can use a combination of their PTO, their paid sick leave entitlement under FFCRA. And then after that first 80 hours, the remaining 10 weeks is paid at 2/3 their compensation. Okay, I'm still confused about how many weeks are required at full pay for items 1 through 3. This poster indicates only 2 weeks. Isn't only item 5 the qualifier for additional 10 weeks? So no, so again, this goes back to our government never making things super easy. So if you have the options of, if an employee has a qualifying reason of 1 through 3, they have 80 hours of sick time that they can take. If it's option number 5, if it's qualifying reason number 5, they still have the 80 hours, but they also have an additional 10 weeks. And that additional 10 weeks is paid at 2/3 their compensation. It's only if the qualifying reasons for your employees, if they fall under options 1, 2, or 3, Those are the only three options where the entire time of up to 12 weeks is 100% fully compensated. Why wouldn't someone want to use the paid sick leave first versus their own time? So that's pertaining to the expanded family medical leave and not the paid sick leave. So the reason why they have the option there is if for some reason they wanted to keep their PTO time for something later in the year, if they're able financially to take unpaid time. But if they dip into the FFCRA paid sick leave, then then they're not going to have that to use if later down the road they get diagnosed with COVID-19. So that's why the government is giving them the option to choose either unpaid, they're using PTO time, or dipping into their own paid sick leave if it's like option 5 that falls under the expanded family medical leave. Another question, is there a difference if people are laid off versus terminated versus furloughed? So great question. So yes, so furloughed. Furlough means that you've made a determination that for whatever reason, there is not enough work that is provided for individuals right now within your organization. And so you want to temporarily close your doors for a couple weeks, a couple months. You can furlough an employee for up to 1 year maximum. And when you furlough someone, that means that they're still on your payroll. They're just not earning any income, but you are maintaining their benefits. And you can decide to pay their full benefit costs, meaning your employer costs and the employee's cost, or you can continue to pay your employer cost and the employee pays their employee cost, and they're just writing a check to the insurance carrier for that while they're on furlough. A layoff means that it's basically a friendlier version of termination. And so they're not maintaining their benefits, they're not on your payroll. If you were to rehire them, you have to do all new paperwork all over again. Their tax forms, their new hire forms, everything. Now, employees who are on furlough and have been laid off both of those options still give the employee to file for unemployment. So even if they're on furlough and they're maintaining their benefits, they can still file for unemployment. So in my opinion, if you as a business owner know that your doors are only going to stay closed for a short period of time, the furlough is the best option for you and also for the employee, because you're able to easily bring them back. They just come back to work. There's no new paperwork. It's as if nothing happened. And the employee is still able to file for unemployment and keep their benefits. Termination is just that. The employee's been fully terminated and they're no longer your employee. If employees just say they aren't feeling well and want to take time off, is it PTO is normal? Do I need to have them go to the doctor to be tested for COVID-19? When the Department of Labor first released this new act, there was no clarification on what that meant. So that would be option number 2 or number 3 under the 6 qualifying reasons. Now the government or the Department of Labor's regulation has been, if a employee is going to go out on self-quarantine, then they need to provide documentation that a medical provider has given them either that diagnosis that they have tested positive for COVID-19, or if they're awaiting test results, they need to go and quarantine themselves until their test results come back, because their symptoms are similar to what COVID-19 is. So unless they provide you with that documentation, then it's their own PTO. So if they want to, not come into work, I would say perfectly fine. I understand it. We'll use your own accrued PTO for today. I would recommend though that if you're feeling like you may have COVID-19, that you go get tested and you let us know what your medical provider has stated. And then at that point, if they're positive, they need to write a statement to you letting you know what's happened, and then also provide you with the medical diagnosis. And then at that point, it would fall under the number 2 or 3 under the paid sick leave option. We have 2 employees who were exposed. We sent them home to quarantine for 2 weeks. Will they need a doctor's note to return? I would say for safety reasons for your employees who are continuing to work, yes. I would ask them if they're not experiencing any more symptoms, I would ask them to, see that same medical provider and ask if that medical provider feels comfortable with releasing them to come back to work, just so that the rest of your employees are comfortable and are safe, and that that if those 2 employees come back, that it's not going to put your other employees potentially at risk. Does the stay-at-home order in Florida qualify as option 1? That's a good question, and it's probably one of the most highly debated of all of them so far. And the shelter-in-place orders are a little tricky. I'm going to read what I have found, and then I'll interpret that as well. But it says shelter-in-place orders. Up until now, it has been unclear whether shelter-in-place orders issued by state and local governments could trigger an entitlement to be paid leave under FFCRA. The Department of Labor clarified that employees who have work to do but are unable to work or telework because of a government mandate to shelter in place may be eligible for paid sick leave. However, this is not the case if the employer has no work for the employee to do. So it's basically stating that if they're unable to work or telework, then yes, they would potentially be eligible. However, if it's the case where it's a shelter-in-place order but you have no work for them to do, that would make them qualify. So it comes down to if you're an essential business or not, and if you have work for them to do. What I would state is to try to let your employees, to set them up to be able to telework as much as possible, and that would help solve any issue around the shelter-in-place option. If an employee visits a state that Florida requires 14-day quarantine for, does employee qualify for number 1, and do they have to provide any documentation? If they're being told, so if they go to New York City and come back, we actually had an employee very, very early on that went to, that just traveled via air travel, and all of this was starting to happen. So when they came back, we talked with them and we asked them to do a 14-day self-isolation from home. We provided them all of their equipment to be able to work from home while they self-isolated. If you're not able to provide them to telework, and yet they have to go into a self-isolation, then yes, this would qualify. That's why it's in your best interest as much as you can to set your employee up to be able to telework. Looking through some other questions. All right, if I'm a small business with fewer than 50 employees, am I exempt from the requirements to provide sick leave or expanded family medical leave? Yes and no. So if you have 50 employees or less, you have the option to make a business decision not to follow the guidelines within this new FFCRA. Now, I caution you with that. The Department of Labor, you can guarantee as of April 18th, their auditors are going to be out in full force, making sure that employers are in compliance with this act. Now, if you deem that following these new FFCRA guidelines are too detrimental to your business financially, that it's going to potentially cause you enough financial harm that you will have to close your doors, then that's your decision that you need to make to not follow these guidelines. But you need to be able to clearly show that if for some reason you were to be audited. So if you have less than 50 employees and one of your employees comes to you and says that they've been diagnosed with COVID-19 and they need to shelter at home, that's going to fall under either option 2 or 3. Their paid FFCRA sick leave goes into effect. If you deem that it's too much of a financial hardship, you've got to be able to showcase that if that employee then reports you to the Department of Labor and that flags an audit. Now, there's also random audits that occur. That's a scary situation if that happens. But with this was a way for the government to keep employees paid and safe during this COVID experience that we have right now. You just need to make sure that you can clearly document the decision that you made based on your financials with this new act. How do you calculate the 50 employees or less? Is it as of a certain date, an average over a period of time? So it's going to be the number of employees that you have actively on staff as of April 1st, when this new act went into effect. So if you had at least 50 employees, then it's the number of employees that you have the day that the act went into effect on April 1st. So they aren't going to look back like FMLA is a 12-month look back with at least 50 employees. This is just the number of employees effective April 1st when all of this went into play. One of the other topics that I wanted to cover too is under the qualifying reasons, number 5. So that's the one that an employee, if they come to you and tell you that they need to care for his or her child whose school or place of care is closed. So the caveat to this is the government only considers one parent being a necessary person, and I used air quotes there, to be able to take care of their child or children. So if your employee is the necessary parent, then that's great. But if it's going to be a combination of the two, the two parents taking care of the child or children at home, then that would be a scenario of either intermittent time off under qualifying reason number 5, which falls under the expanded family medical leave and not the paid sick leave. And so that would just be a conversation that you have with your employee. Is your employee going to be the person who's going to be taking 100% of the care of the children, or is it going to be separated? That's just a light conversation that you have to have, because the government is only deeming it necessary for one parent to be taking advantage of this at a time. If an employee gets 2 plus 10 weeks paid for qualifying reasons 1 through 3, after that, do they get up to another 12 weeks FMLA at 2/3 paid? No. So it's a total of 12 weeks time. So the paid sick leave option is the first 80 hours, which is counted as 2 weeks. And then if they can't come back to work, it's an additional 10 weeks of 100% paid time, so a total of 12 weeks. The expanded family medical leave, it's the first 80 hours, and then they have an additional 10 weeks of time. So again, a total of 12 weeks. But under the expanded family medical leave, that last 10 weeks is what's paid at 2/3 their compensation. Now also keep in mind, since this is in addition to FMLA, it's a combination of, it's not in addition to. If you have had employees this year who have been on FMLA, then if they were to use any of this COVID-19 FFCRA time, then that would be deducted out of any time that they've already taken this year for FMLA. So again, if you have an employee who's hypothetically been out on FMLA for 2 weeks, then they get diagnosed with COVID-19 and they need to take the paid sick leave. Well, since they've been out for FMLA for 2 weeks, they would only have up to 10 weeks of the paid sick leave under FFCRA instead of the full 12 weeks that this act has now given them. Just looking if there's any more questions. I don't see any more questions. One more. Where can we find this sheet? So if you go to the Department of Labor website, dol.gov, /coronavirus, it'll take you to the coronavirus information page. And it will, there you can find all of the fact sheets, the Q&As, the required poster for your work sites and also to be emailed. Or you can also go to our Darshakau Insurance website, and at the very top on the homepage, just click on COVID-19 resources, and then you're going to just click here, the Department of Labor COVID-19 fact sheets, Q&A, and required posters. And that'll, from there, you can easily download anything that you need to. So oh, one more question. Another question's coming in. Can one employee be determined no work for them to do and be included as option 1 and others be option 5 since they have work and are not able to care for children? So can one employee be determined no work for them to do? Let me go back. Yeah, so under option 1, if it's under an isolation order and it's determined no work, and then you have others under an option 5, yeah, so that would be two different sick leave options. So if you have an employee who is covered under qualifying reason 1, then they're going to have the paid sick leave option, the first 80 hours of 100% paid sick leave, and then additional 10 weeks up to 10 weeks as well of 100% paid sick leave. And then you could have others who fall under option 5, qualifying reason option 5, if they have children that they specifically have to take care of and are going to be the primary parent or guardian who needs to take care of those children, and they're not able to perform telework. So again, I can't stress the ability enough for the telework option. If you have the ability to set your employees up from home to where they can do their full job, that's gonna save you from dealing with a lot of this mess. So if you haven't done so already, I know that you're going to have a lot of positions, probably depending on your industry, where you don't have the ability to have your employees work from home. But if you do, I highly recommend that you set your employees up to do so as we go through this. So I think that's it. I enjoyed this conversation with you all. I hope that you guys got a lot of benefit out of it. You are more than welcome to reach out to me. My email address, it's pretty long, but it's just jsmith@dar, D-A-R-R, Shackow, S-C-H-A-C-K-O-W, insurance.com. My direct office line is 352-244-0325. And again, feel free to reach out to me anytime with any questions. I am happy to help. Thank you all. I really appreciate your time.